All right, our legal power panel is here with us tonight, and we're going to be starting here with Jimmy Kousouris. He is a criminal defense attorney in Manhattan, lectures at New York Law School. We're putting on his microphone as we speak, so go ahead, just put it on, Dave. Let's take away the magic of TV. And he's also a visiting professor at the University of Birmingham in England. Ooh, good sir.
Thank you, boss.
Mayo Bartlett, an attorney, former chief of the Bias Crimes Unit in Westchester County's District Attorney's Office. He's got a couple of high-profile cases as we speak. And Mark Furnish, a professor at Brooklyn Law and an attorney who has, listen carefully, gentlemen, argued before the highest court in the land. All right, I want to talk about two cases, very different issues, but all have the same issue as to who shall decide here. A pair of cases focusing on who makes the ultimate final decision about life and death, especially when a person cannot live without the help of a machine. We have the first case of Marlise Munoz of Crowley, Texas. She was pronounced dead after likely suffering a pulmonary embolism, and she's kept alive on a ventilator. Her husband and her family, and her father, by the way, retired police chief, decorated veteran, they all say she made it clear she would never want to be kept on life support if there's no chance of recovery. But the state, they said, I'm sorry, we cannot honor your wishes because she is pregnant, and it's against the state law for a pregnant woman. She was 12 weeks at the time when this decision was made here to be removed from life support. Meanwhile, onto the West Coast, we're in Oakland, the story of a 13-year-old, Jahi McMath, declared brain dead after sleep apnea surgery. Doctors moved to remove her from life support. Her family won a court order to keep her on a ventilator. I know there's no simplistic answers here, but if we start with the Texas case, Mayo, the family says we want to honor her wishes. Her husband said she made it very clear before her death that this isn't how she wanted to live. The state yet gets to decide. I mean, for those who argue about big government, isn't this the poster child for where government may overstep its boundaries?
Absolutely. Normally we talk about your right to privacy and that the privacy extends so much within the home, but it doesn't go anywhere greater than it does within your own body. So if the government's going to tell you that you don't have a right to pursue your own wishes, basically, when you look at living wills, for instance, it would be the equivalent of you saying, I don't want to be sustained, and they end up reviving you and they keep you on life support. And in addition to that, there's a tremendous cost involved with it. So now you're going to hold that family responsible for the medical care in all likelihood.
You know, the Munoz family and the father said, you're basically, my daughter's a host who's supporting a fetus, and that's what this has redounded to. But it's a simple policy thing, which is the state says, you know, if the person can support the fetus until delivery, the family has no choice. It just does seem rather extreme that you can force someone to take a child to term when the person couldn't live on their own means. Well, they have to artificially keep them alive.
I think it depends on two things, Rich. The viability of the fetus, first of all, and second of all, it's sort of a red herring in this case to say that she didn't want to be kept on in this state because there's no indication that she would have made the same choice had she known she was carrying a child or a potential child at the time. So it behooves the lawyer who's drafting the living will or the healthcare proxy to explain to the woman, you know, what if you're pregnant?
But don't any rights go to the living spouse?
Well,
to decide in effect both
I don't think so. I don't think so, because it would be the woman's right to decide, irrespective of the living spouse's view, whether she would want to abort a non-viable fetus or not. The spouse should have a say, but he's not capable of saying what choice she would have made had she known she was pregnant. None of us is capable of doing that. So as a policy matter, to prohibit the taking away of life support when the fetus is viable is a no-brainer. It's a tough case.
What do you make about that case, and also the case in Oakland, which is in many ways even more complicated because you're dealing with a 13-year-old?
Well, what Mark is saying, though, is right on point. And here's the litigation that's going to follow. What happens when there is a healthcare proxy or there is a medical directive from the woman to her husband or to her significant other that says, if I am in this state, and by the way, we're not talking about a vegetative state, we're talking about legally dead. What happens if there is a proxy that says, abort the child? You and I have decided that these are my wishes, and that is in an actual medical proxy. In a proxy, does the state of Texas then have a right to deprive these people and this woman of what is otherwise
Right.
a constitutional right. I think that that will be part of the litigation that follows, and that this is what will come of these
how about
cases.
I get it.
The answer
Yeah.
to that, I think, should depend on whether the fetus is viable or not, because the right should be coterminous with the abortion right.
Well, exactly. Assuming that it is legally possible to have the abortion, can the state of Texas then say, you know something, as a matter of policy, we're not going to let you
Real
do
quickly,
that?
guys, because I want to get this for the break. In Oakland, 13-year-old, brain dead. The state, the hospital says, she can't be supported other than life. We're going to, take her off the ventilator, and the family says no way, no how. Who shall decide there?
Oh, goodness, that is such a painful thing to even think about, but the child is dead. A death certificate was issued in December. And brain dead is a determination of death, perhaps in a different way than we're otherwise accustomed to, but basically there is no reviving. You're not
Right.
keeping the person alive. You're keeping somebody who is legally dead, just having their organs sustained.
Well, there have been certain circumstances where people have been pronounced brain dead, and then after a lengthy period of time, they come out of the coma. And
But it's not a coma.
well, it's not a coma, but even when you start to look at this, why would you keep someone alive who's brain dead under any circumstances then at that point? But it comes down to, really, it's a libertarian question, and it comes down to how far do our rights extend, and then what is the imposition on other people?
In many ways,
Yeah.
these are both
Absolutely.
libertarian questions. And also, where's the role of government start and stop here? And where does your right to extend life? And who pays for it? And there's all these things colliding at the same time. Okay, when we come back, my guests here have been on both sides of the justice system.
Not me.
Not you. I didn't drag you into the prosecutorial side here, but these two guys have. Just how tough is the system here if your pockets aren't deep? Well, we got some facts here that also lend this, and how much prosecutorial misconduct really does go on. These guys will weigh in. Stay with us.